Thank you. It's a pleasure to follow on from two such fantastic presentations. And I'd like to start by thanking Konstantina and all the organisers for the invite. I'm just so sorry that I can't be with you all there in beautiful Vienna. So in this paper, I want to talk about the place of digital open source evidence, like Jeff has just defined, in the domestic prosecution of international crimes. And specifically, I wanted to share with you all some insights from a mock admissibility hearing on open source evidence that I helped to organise with some colleagues from GLAN, the Global Legal Action Network, and Bellingcat earlier this year. So just by way of context, Jeff mentioned in his presentation the arrest warrant against Al-Barvali in the situation in Libya that was issued in 2017, relying to a large extent on videos posted to Facebook, allegedly showing the accused committing murder. And at that time, this was seen as like a really transformative development in the landscape of human rights fact-finding and our ways of knowing about human rights violations, you know, really leveraging this information that anyone can access in the pursuit of accountability. But by now, it's almost a given that social media evidence will play an instructive role in criminal trials. Actually, I think both domestically and internationally. So domestically, you just need to look at, for example, the conviction of the policeman who killed George Floyd to see just how important social media evidence can be in addressing power imbalances, challenging dominant narratives, and indeed in overcoming some of these issues that can arise when it's one person's word against another. For UN, human rights fact-finding missions, commissions of inquiry, as Federica mentioned, these are really harnessing the potential of open source or user-generated evidence. You just need to look at any report from the last couple of years, and more likely than not, you'll see that it's quite common for them to include searching social media in their methodology. And before the ICC, Al-Barvali wasn't a one-off. By today, several ongoing and completed cases have used open source evidence in some way. We can talk a little bit more about those in the Q&A perhaps. Domestically too, we see what we call user-generated evidence playing a really important role in the national prosecution of international crimes. So Christian Richer mentioned some of the German cases in his presentation at the conference yesterday. And my PhD student, Karolina Aksamutowska, has just published an excellent article in that special issue of the Journal of International Criminal Justice that Federica mentioned, where she analyses the use of this kind of evidence in cases from Sweden, the Netherlands, Germany and Finland. And her article is open access right now, as is the rest of the special issue, if anyone's interested in checking it out. I'd highly recommend that one to anyone seeking to learn about how this kind of evidence has been collected, analysed and presented in cases in those jurisdictions. I would also really recommend the article by Kelly Matheson, Chiara Gabriella and Raquel Vasquez Llorente, which talks about a trial in the Democratic Republic of the Congo, which utilised evidence that had actually been captured through the Eyewitness app that Federica mentioned. So this is some of the domestic landscape. But all those countries I've just mentioned, broadly speaking, come from the continental tradition. And so they have a free proof approach to the admission of evidence. And for me, as someone working on this stuff from England and Wales, which has this stricter common law system and the stricter admissibility regime in place for evidence, a question I would often get asked is, well, what would happen here? What would happen if we wanted to introduce open source evidence to a human rights case in England and Wales? And the short answer had to be, I don't know. We have, of course, had domestic cases that have availed of CCTV evidence or messages from social media. But what's unique about the particular context of human rights fact-finding is the provenance of the piece of evidence. So often we don't know and can't find out who captured this piece of content and who first uploaded it online. And so that person in turn obviously can't be called to testify in introducing the evidence. And at the same time, my colleagues in GLAN and the Global Legal Action Network have been doing a lot of work on accountability for breaches of international law in the conflict in Yemen. And through that, they've been involved in preserving and verifying relevant social media evidence showing airstrikes conducted by the Saudi-led coalition. And GLAN worked with the investigative journalism organisation Bellingcat in coming up with a methodology for doing this collection and verification work. And they were really interested in exploring what possible challenges might be raised to their methodology in a real life case, if this was to come up, as we hope it will, before the courts in England and Wales. So with that in mind, the whole idea of holding a mock, what we call voir dire admissibility hearing was born. So we devised a completely fictional case with a fictional defendant where a real piece of footage from Yemen that had been found on Twitter and verified by Bellingcat was really central to the fictional prosecution case. So the hearing was presided over by Judge Joanna Corner, who at that time was a judge in England and Wales, is of course now a judge before the ICC. And we convened two teams of counsel, so Helen Malcolm QC and Josh Kern for the prosecution, and Andrew Cayley QC and Sheena Minashawn for the defence. And Elliot Higgins and Nick Waters from Bellingcat acted as witnesses and were subject to cross-examination. So before I go any further and show a couple of clips from the hearing and discuss it a bit more, let me underscore a massive caveat that this was a fictional exercise. Of course, not binding in any way on any court, and nothing should be read from it in terms of how future real life cases might unfold or how judges or lawyers that were involved might act in future cases. But the entire hearing, which is about 2 hours long, and Judge Corner's fictional ruling are both available in full on YouTube. So if of interest, you can check it out afterwards. But today I just wanted to highlight a couple of points that came up in the mock exercise that I thought might provide an interesting starting point for discussion when we start to think about how open source evidence can be used in proving international crimes and some of the challenges that might be raised to it. So let's hear first, I hope this works, from Helen Malcolm QC explaining the relevance of the video for the prosecution case. Al-Qahtani is the name of the fictional defendant in the trial. So let me try and do this. We go out.
That video, if credible and accurate, provides valuable evidence and answers each of the objections of Mr. Al-Qahtani in his interview, because it shows the time of day, it shows the presence of civilians, it shows widespread damage.
Yvonne, could you maybe pause the video? I will turn up the volume a bit. 1 second.
Second strike. It shows civilians helping those injured people. And it shows that any dust and smoke from the first strike had cleared prior to the second strike, so that there would have been nothing obscuring Mr. Al-Qahtani's view from the cockpit. And finally, it shows the second strike. It therefore, in our submission, passes the first test of admissibility in that it provides what is clearly relevant evidence.
So that's the, sorry, the volume was a little low when I shared it first, but I hope you got the gist of that. That was the relevance of the video from the prosecution's perspective. Now, the defence line of attack had two strands. The first was that the video itself was inadmissible because it was so lacking in authenticity and reliability. And the second was that the expert report that accompanied the evidence was inadmissible. Let's hear Andrew Cayley QC questioning our expert witness. 1 second now.
You understand as an expert that your duty is to the court and not to the party that is instructing you.
Indeed, yes.
And you would make the claim, and I think you've made it already, that you are an independent witness giving objective opinions. Is that right?
That is correct, yes.
And you would say those opinions are unbiased?
I have a different interpretation of bias. From my experience with analysis and intelligence analysis, bias is something that can be identified and mitigated, but it cannot be eliminated completely.
Yeah, we'll come to that. Thank you. Yeah.
So I think sometimes people who don't have a lot of knowledge of legal practice think that the role of the expert witness is kind of like a hired gun for whichever party instructed them. But the expert's duty is, of course, to the court and the court alone, and they have a duty to disclose anything that might undermine their own conclusions. And that's really what Andrew is pointing at here. But you heard there the issue of bias and differing interpretations of what bias means. So the legal definition for expert witnesses says that an expert witness needs to be unbiased. But what Nick was saying there, from an investigator's point of view, is that actually we all have personal, cultural, and structural biases that impact on our perceptions, and that we need to be aware of those and take countermeasures to ensure our objectivity. And algorithmic bias, which Federica mentioned too, was also a factor that came up in the mock hearing. Let's see a little bit of this.
Google makes its or has a reputation because it shows people results that are most relevant, or that Google assesses are most relevant to a person.
Yeah.
So Google will collect huge amounts of data on individuals.
Yeah.
And then when, say, for example, I search a particular subject or about a particular subject, Google will then show that person what it believes to be the most relevant material for that person.
Yeah. So I see. So in other words, if somebody is in the habit of searching for airstrikes, Google will recognize it and immediately throw up a load of airstrikes. Or what's that effect?
I wouldn't be sure if it'd go down to that kind of specificity, but certainly in terms of if a person's interested in a particular conflict, then Google may identify that.
I wanted to share that clip. I really like that part of it because the judge gets it. And, you know, we often hear this idea that justice systems are ill-equipped for this new kind of evidence because judges are unfamiliar with the ins and outs of social media. And while it's true that judges probably don't spend as much time on scrolling on Twitter or Instagram as some of the rest of us, you know, they are smart people. And yes, some of this stuff is complicated, but so too is DNA evidence or other scientific questions. And they come up all the time in, for example, criminal negligence cases or ordinary criminal trials. So judges deal with complicated technical evidence all the time, and I think we have to give them credit for that. I want to turn to the issue of who is an expert, because this was really key in this fictional case that we put together. So Bellingcat and other groups who do open source investigative work and train others on it are always really keen to point out that, look, anyone can learn this in a couple of hours, at least the basics of verification of online open source information. But does that actually undermine their claim then to expertise? And unlike, say, a medical expert or an engineer, there's no professional body that open source investigators can seek membership of. There's no sort of established scientific community around this stuff. So let's see what Judge Corner had to say about this in her ruling.
Well, the field of analysis of video material to establish its significance, reliability, or authenticity is one which appears to be of relatively recent origin and is one which is composed of a number of factors. One is the application of technical knowledge, for example, an understanding of the operation of metadata and methods of digital alteration. Another is knowledge of techniques such as geolocation and chronolocation. However, much of the analysis relies upon factors such as the use of search engines for obtaining satellite imagery and evidence which supports or undermines the content of the video, which do not require specialist expertise, but are derived from training and experience in the examination of such material. The Berkeley Protocol, referred to by Messrs. Higgins and Palmer, sets out the methodology required to conduct proper investigations into open source material. Whilst Mr. Palmer has no technical knowledge in respect of metadata or digital alteration, his other qualifications, and more to the point, his experience in this kind of analysis, make him a person who is able to, and again I quote, assemble what can properly be described as a balanced body of specialized knowledge which would not be available to the tribunal of fact. Having heard him give evidence, I am satisfied that he is giving an opinion which is objective and unbiased and within his area of expertise. In the words of Lord Bingham, he is not a quack, a charlatan, or an enthusiastic amateur.
I have to say, I breathed a massive sigh of relief when she confirmed that, in her opinion, Nick, our friend from Bellingcat, wasn't a quack, a charlatan, or an enthusiastic amateur. I'm not sure he would have ever forgiven us if the judge had reached the opposite conclusion. So you heard some reference there to metadata, and I mentioned earlier that one of the defense arguments was that the video was so lacking in reliability and authenticity that it wouldn't be in the interest of justice and fairness to admit it. And the defense actually had some very good arguments here, because the creator of the video was unknown. And in fact, the video that we showed in the mock admissibility hearing had clearly been edited, because there were two segments which apparently had been spliced together. So either it was the same video that was cut in half and part of it moved, or else it was two videos that had been stuck together. So the defense were able to argue, well, what are we not seeing here? Is there a chance that it has been manipulated to remove some exonerating evidence? And because it had been posted to Twitter, that metadata, that identifying information, had been stripped from the video, as is common with social media platforms. So what techniques were used to verify the video, where it was taken and when it was taken? Here's Nick explaining the process called chronolocation. Sorry, there we are.
So as the sun moves through the sky, obviously the length of our shadows change. Therefore, you can establish the time by using the proportional height of the shadow compared to the object that is casting it. So as well as, for example, using a person as a sundial, so looking at the angle of shadow, you can compare the proportionate length of the shadow versus the object casting it. And that can give a rough time window. Within the analysis, in order to mitigate for the effects of, say, for example, a type of lens distorting the view of the shadow, or the fact that the ground is covered in rubble, and so therefore it's difficult to establish the exact length of the shadow. We carried out this calculation, I believe, 8 times, if I recall correctly.
Yes.
That resulted in a mean time of 10:33. And I am confident that that is within the extremes of what the time may be, because if you change the time from 10:33 by either 30 minutes before or 30 minutes after, the shadow either becomes too long or too short to be consistent with the shadow that you see in the video.
There were also other methods used, which I don't have time to go into today, but like geolocation, matching the video with buildings, other landmarks in the background. The final point I thought was interesting, and this is the last clip I'm going to share with you, I really hope it's working okay over there in Vienna, is this one. Let me just quickly share. Is it sharing? No.
The interests of justice require that care is taken by judges before admitting into evidence material, particularly that obtained from internet searches, which is adduced for the purpose of convicting a defendant of a crime. Recent events, whilst outside the sphere of criminal trials, have all too clearly shown the dangers of material being uploaded to the internet, which is colloquially described as fake news.
I thought that was really interesting that Judge Corner brought this point up, and it really reminded me of Judges Van den Weingart and Morrison's opinion in Bemba and Judge Henderson's reasons in Bagbo, where they also referred to this era of fake news. So it struck me that judges they seem to be very alive to this issue. How am I doing for time? Sorry, I will stop talking. Okay, you can cut me off if I'm gone over time. In the mock hearing exercise, one thing that came up quite a lot was this question of whether the video could be a deep fake, an AI generated super realistic fake. And I suppose one of my big worries, and Jeff knows this is one of my hobby horses, is that we're in something of a golden age for the use of open source evidence and accountability processes. And I'm worried that emerging threats from disinformation and advances in deepfake technology might lead to courts saying, actually, we can't trust any of this kind of evidence. So the Canadian philosopher Regina Rini has made the point that there is a risk we might throw the baby out with the epistemic backwater, reflexively distrusting what is real footage as probably fake. So I think that's something we need to be aware of. Witness, the Video as Evidence organisation, have done a lot of great work on this, which they called Prepare, Don't Panic. Maybe it's something we can talk about more in the Q&A. So just to wrap it up, well, what did we learn from this mock admissibility exercise? Well, I started this whole discussion with a disclaimer, and I'm ending it with another reminder. This was a fictional exercise, not binding in any way on any court or any judge. But the second major caveat I would note is that even though Judge Corner ultimately decided that the piece of evidence could be admissible, admissibility only tells half the story. It tells us nothing about the weight that this kind of evidence might be given in a real trial. And Judge Corner really emphasised in her ruling that she would be giving the jury instructions and warnings, highlighting the drawbacks of this kind of evidence and how they should treat it. So I think when it comes to the use of open source evidence in accountability processes, there's still a lot of unknowns and a lot of unanswered questions that we just have to wait and see how practice plays out. But this exercise gave some insights into perhaps some of the challenges that might be raised in legal proceedings in the future. So thank you all very much.